what exactly SB 1063, the 2021 amendment to 12910F, did and did not do to the standard of review in 12910F. First, had the legislature intended to replace substantial evidence review with de novo review in 12910F, the legislature would have spoken clearly and directly on that issue, not through opaque or obscure language such as what the opinion glommed onto. Second is that SB 1063 left substantial evidence intact in the statute. It did not repeal the substantial evidence standard in whole or in part. And third, SB 1063 expressly used the term de novo in creating de novo proceedings, or a right to de novo proceedings, in 12910D, and did not use similar language in 12910F. There is no mention of the term de novo in ARS 12910F at all. And so the no deference command in SB 1063 has to be construed against this backdrop of these 3 points. And it's there where the opinion here went wrong. The opinion construed the no deference command in SB 1063 as doing exactly what the statute did not do: repeal substantial evidence and replace it with a de novo standard. The correct interpretation we would submit of SB 1063 is that substantial evidence remains the standard of review under 12910F. The no deference command in the 4th sentence added by 1063 applies only when the court is reviewing court, so the superior court, is deciding a question of fact. That's how the statute is phrased. Substantial evidence is a question of law and not a question of fact, and so on its face, the command doesn't apply.
So, Mr. Herring, I have to tell you, I found the Court of Appeals opinion internally inconsistent in numerous regards. And there's no question that the court sometimes says that we don't have substantial evidence review. And then when it articulates the applicable framework and applies the applicable framework, it suddenly reappears. So I want to direct you to paragraph 62 of the Court of Appeals decision, which sets forth the framework that it arrives at and that it purports to subsequently apply, and ask you if there's anything about that paragraph, putting aside the places where the court does seem to state pretty unequivocally that SB 1063 did do something to substantial evidence review. Is there anything about that paragraph that you disagree with?
Justice Bollock, a couple points on that. So first off, the paragraph 62 puts significance on this term, the regulated party. And in so, and I can get in a little bit later into the construction, into how we would construe the term the regulated party. But the paragraph misapplies the regulated party as in the first instance. I'll come back to that in just a moment. The second way I disagree with this paragraph is that the paragraph creates this two-step process where it assumes a de novo standard of review of specific fact findings. And then once the reviewing court decides specific fact challenges de novo, then we go back and redo the whole thing under substantial evidence. I mean, if you're familiar with the term Potemkin Village, that's kind of what I call the substantial evidence review under this paragraph. It's not really substantial evidence review because whoever wins on the de novo review necessarily wins on the substantial evidence review. And it inserts this de novo standard into the statute where it doesn't exist and where what was never added by the legislature. Let me go back to the regulated party issue real quick. So what struck me, one of many things that struck me about the opinion is that the opinion puts all this significance on the term regulated party, yet never construes the term. Never ever says anything, well, what is a regulated party? What is a non-regulated party? And the opinion here seems to suggest that there's these two buckets of regulated party, non-regulated party, but doesn't tell you what they are. Now, the Commission's interpretation is that you have to read the second sentence of 1063 that uses the term regulated party in F conjunctively with subsection D of the statute, which uses the term agencies that regulate in creating the trial de novo right. And so the regulated party inquiry is simply an inquiry into whether a trial de novo was requested under subsection D and whether a trial de novo was being performed under subsection D. It's nothing more than that. And you get there by reading those two sentences together. And I guess I'll add a third way I disagree with paragraph 62. The third, it says second, and I'm quoting from the opinion now, second, it, meaning the reviewing court, should identify the agency action at issue. Well, there's almost never an argument about what the agency action is. Title 41 and Title 12 tell you what the agency action is. It's the final administrative decision. There's usually no...
So those are the same thing? The final administrative decision and the agency action?
For purposes of 12.910, yes.
Always.
The agency action is always the final administrative decision. It's never the initial action taken by an agency or the administrative law judge's recommended decision. And so, this test in paragraph 62 where it says the court needs to identify the agency action at issue, that's almost never at issue in a case like this. You appeal from a final agency decision. So in this case, Mr. Ron Sims appealed from the Commission's decision. There's no need to go back and figure out whether it's that or whether it's an initial action or whether it's an interim decision or whether it's something else.
Well, as used under 12.910F, it talks about agency action. And I know the Court of Appeals made this distinction between an agency action and agency decision, but at least in the context of the statute we're talking about, agency action seems to be the administrative decision that, at least as referenced at least in F, that's what they're talking about, reviewing administrative records, supplementing evidence presented at the hearing. The court may affirm, reverse, modify, vacate, remand the agency action. Is that a correct interpretation, that there at least action is decision?
Yeah, the agency action the reviewing court is reviewing under 12.910F is the final administrative decision. That's correct. It's the final administrative decision. In this case, it's the Commission's decision.
So to try to put a finer point on this, those two terms we're talking about are synonymous.
Correct.
Okay, and you believe that Court of Appeals erred there?
Yes, absolutely. The Court of Appeals, later in the opinion, doesn't review the Commission's final decision. It reviews the Department of Gaming's initial decision to deny Mr. Sims's license application. It identifies the initial denial as the agency action being reviewed. And unless there are any other questions, I'd like to turn it over to Mr. Torrey.
Fine, thank you.
Thank you.
Almost right at 12 minutes, too.
Good morning. May it please the Court. My name is James Torrey, and I represent the TV racing parties. To pick up where Chris left off, if the legislature had intended to enact a sea change in administrative law, it would have done so very clearly and specifically, not obliquely. As Justice Scalia said, Congress doesn't hide elephants in mouse holes. If they're going to make a big change, they're going to make it clearly. And they didn't do that here. They kept the substantial evidence standard. And nowhere did they state a new de novo standard. More than that, they did state a new de novo standard in 2021 in Part D, showing they know how to express that standard when they want it. But they didn't put the same standard in F. Instead, they retained substantial evidence. Showing that this wasn't clear from the time when the 2021 amendment went into effect until the Court of Appeals opinion in this case, every court that had applied 910F continued to apply the substantial evidence standard. Not a single court applied de novo because it was clear that that standard still applied. So we cited some cases in our brief, but Shin, Marsh, Batty, every case between 2021 and 2025 continued to apply substantial evidence. And if the legislature had wanted a new standard besides substantial evidence to apply, not only would they state that standard, but they would have been very clear in specifying when the alternative standard would apply, like they did in C, like they did in D. They were very specific, citing the statutes where those other standards apply.
Now, two things can be possible at once here, it seems to me, and asking you to react to this. The substantial evidence final analysis can remain intact, but there can be a sea change with regard to factual findings. Ordinarily, we apply arbitrary and capricious or clearly erroneous to factual findings. This really is, even though the words de novo are not used as to the factual findings, this really does instruct the reviewing court to look at those factual findings ab initio with absolutely no deference to the agency. I think, isn't it true that both of those things can be true, can remain true?
Well, no. I think that that's not what it's instructing. The fourth sentence does not say the court shall review all agency factual findings without deference. That would have been easy to say. It also would have been easy to say the court shall review all findings without deference. Easy to say. They didn't say that. They said the court shall decide all questions of fact. So the focus of the 2021 amendment is on what type of question the court is answering, not on what type of agency finding the court is reviewing.
Well, are those questions brought up? I mean, does that kind of relate us back to subsection A, when I guess now you're in front of the Superior Court and questions can be raised? A party can request an evidentiary hearing to the extent necessary to resolve those questions, or the court can still rely on the record, and it seems like can make their own decision. It doesn't say anything about de novo, doesn't say anything about substantial evidence under A. So how does A and F fit into this scenario?
Well, I believe A says that they can do an evidentiary hearing to answer the question in F. So they can have an evidentiary hearing to apply the standards in F. So
right. To the extent necessary, or to make the determination regarding which, I mean, it seems to be, that could be either way. Either the determination is you need to defer to any least credibility factual, least credibility or factual findings, or de novo. It doesn't say really under A.
Well, A says that you, to the extent necessary to make the determination, that's a requirement in order to have an evidentiary hearing. There are two requirements. You have to have a request within 30 days, and then the court has to decide that it's necessary to have that hearing to make the determination in F. But F still sets the standard for how you review, and the standard says substantial evidence. And our reading of the fourth sentence, it literally says when a court decides questions of fact. And there are situations when a court could decide questions of fact. For instance, in questions of authority or jurisdiction, if the court has to determine if someone is a person aggrieved, well, that's a question of fact that they have to decide, and then the fourth sentence would apply. Certain constitutional questions, we've cited some cases and show those are questions of fact. Those are situations where the court would then need to decide without deference. But substantial evidence, that's the standard. That's the standard in the second sentence.
So are you saying that if, and this maybe dovetails with Justice Pollack's question from a moment ago, if the reviewing court decides a factual question differently than the agency, could that alone lead to a conclusion that the agency decision was not supported by substantial evidence, and the two can exist in harmony? And on the other side of the coin, even if the reviewing court decides the same fact questions precisely as the agency did, the court could still conclude that even notwithstanding the agreement on the fact, it nevertheless failed to rise to the level of substantial evidence?
Well, don't forget.
And I want to make sure I'm understanding if that's what you're saying. Well,
what I'm saying is the standard is still substantial evidence. And in substantial evidence, you're never deciding facts. The substantial evidence, you do not decide facts. All you're doing is reviewing the record to see if sufficient evidence exists to support the agency's conclusion. So you are never deciding fact. That's why it's a question of law. So under A, they would perhaps have an evidentiary hearing to see what the evidence is, to see whether there is evidence to support the agency's conclusion. But in substantial evidence review, you're never deciding facts. That's why it's a question of law, and that's why it doesn't fit. That's why the fourth sentence doesn't affect it.
So what did the fourth sentence accomplish?
Like I said, when they are deciding questions of fact, for instance, and it could come up all the time. For instance, if there's a trial de novo, now all of a sudden you are deciding facts, and they would do it without deference. Or if you're deciding questions of authority, whether the agency had the right to hear it in the first place, whether the agency violated due process, whether there were First Amendment issues. In those situations, then the fourth sentence would apply. But if they had wanted the fourth sentence to mean what the other side says it means, one, they could have just said, you're going to review it de novo. Two, they could have said, you're going to review it without deference, but not talk about previous determinations by the agencies. But they specifically said, when a court is deciding a question of fact.
Actually, they said the court shall decide all questions of fact.
Correct.
And so isn't that any question of fact that is put in controversy by either the regulated party or the commission?
Right, but it's not talking about the agency findings of fact. It's talking about, because it could have said that, but it didn't. It says when the court is deciding a question of fact. So you start in the second sentence. The second sentence tells the court the standard of review. It says the standard of review is substantial evidence. Okay. So the court sees that, the reviewing court. Now they know I need to do substantial evidence review. What kind of question is it? That's a question of law. So then that court looks in the fourth sentence and says, does this sentence change that? No. It says only when the court decides a question of fact. And I'm deciding a question of law because that's what the second sentence told me to do.
Under A, could I know you've got time, quickly. This is a yes or no question. Under A, could a regulated party come in and say, I dispute a question of fact, I want the court to look at it and make that determination?
Only if they had the right to, under C or D, a right to a de novo review. Otherwise, the standard is substantial evidence, and it's been substantial evidence for 100 years.
Okay, so it's no. No.
No.
All right, thank you.
Thank you.
Hey, Mr. Dre.
Good morning, Madam Chief Justice, and may it please the Court. I'm Dominic Dre, and with Matthew Hoxie and Nathan Novak, I represent the respondent, Ron Sims. The other side's three questions have the same answer: text, text, and more text, because the heart of their entire argument is a single error. They read out the amendment of 2021. It creates a new task. It says that in these regulated party cases, quote, the court shall decide all questions of fact without deference to any previous determination that may have been made on that question by the agency, end quote. There are a number of important turns of phrase in that inform the analysis. First of all, there's no when clause. Everything Mr. Torrey says about when you're making a finding of fact is a complete red herring. The court shall make, not some, all fact determinations. Secondly, it takes away deference. This Court has answered, it's paragraph 13 of Horn v. Polk, that the substantial evidence standard of review is deference. The Commission, to its immense credit, finally, in this Court for the first time, conceded at page 5 of their supplemental brief that that's true. And then finally, the deference is taken away from the agency specifically. So if you want to know why the legislature didn't say, just do this all de novo, it's much more targeted than that. They took away deference as to the agency. And our friends on the other side argue this legislative history kind of argument that they look back at the failed legislation from 2017. And one of the big differences is in 2017, it deleted the second sentence entirely. It didn't have the regulated party distinction. And it eliminated all deference for the administrative hearing. Well, that includes the ALJ. So then in 2021, SB 1063 keeps the second sentence, adds the regulated party qualification to the fourth sentence, So that's when it applies, is when you have action by or against a regulated party. Not like if they're making due process findings or First Amendment or whatever it was that the other side offered.
Would you still defer to, would the trial court still defer to factual findings made by the ALJ who comes from the OAH, a separate entity?
Yes, exactly, Your Honor. And so one of the inferences here from this legislative history, if you want to play that game, but I have other reasons, is to defer to the ALJ, who's still intact. The other reasons to defer to the ALJ, and again, the slight daylight between our position and the Court of Appeals decision, which the Court of Appeals acknowledges in its opinion, is that we think the ALJ gets deference on everything.
Well, then, if that's so, make sense of A in conjunction with F for me, because A seem to indicate that if there's a question of fact, either you can ask for a new evidentiary hearing, which sounds like you're not going to be deferring to the ALJ then if you have a new evidentiary hearing, or simply make the determination from the record, which I guess you're going to say you would defer to the ALJ.
Yes, well, Your Honor is exactly correct. So there are a couple of things packaged in that question. First is, what if somebody exercises the option under A within 30 days to have an evidentiary hearing in the Superior Court? That didn't happen in our case. That case is surely coming. And my clients from now on, if they want to change something in the record, will be exercising that option. I think the court could do a service to the state by pointing out that there is a tight deadline in A for counsel and parties who want to change the record. But otherwise, the record includes the ALJ, who saw live testimony, and the record includes a fact reversal by the agency. In this case, all the agency did was insert the word not twice in front of credibility findings. We give the page citations in the record in our briefs. The opinion refers to this. I think it's paragraph 17 or 18. All they did was say, we find Ron's testimony to be, and the ALJ, who heard 21-day trial, 3 days of testimony by Ron himself, 404 exhibits. The ALJ, the independent ALJ, found that Ron was credible. The commission just inserts not in two places, and then, per their patron Jerry's bidding, they take away Ron's license, which is used as a predicate to expel him from the partnership and steal a $250 million racetrack. But all of that, you go back to the ALJ decision because that's part of the record. So what the legislature is doing here is leveling the playing field in regulated party cases, because in those cases, the agency is both judge and party. It's Sims versus the Arizona Racing Commission, and then Jerry, of course, intervenes. But the reason that the legislature does this is to restore a level playing field. In Arizona, unlike in the federal system, our ALJs are independent. They work for the Office of Administrative Hearings.
Is that true for all agencies dealing with regulating parties? I mean, for example, not part of this, but Industrial Commission has its own ALJs. They don't come from OAH. My understanding, I thought, was that sometimes ALJs are actually in-house in particular agencies. I don't know if that's true for anybody that regulates people.
That's a good question. I don't know the answer to that, Your Honor. I know that the Industrial Commission has its own sort of set of procedures, and the appellate standard, I believe, is also different for those cases. So I think you can safely construe 12.910F according to its text and not upset that apple cart. But I do want to return. So you have
before you leave the ALJ, which you may be doing,
please.
Suppose that a commission had adopted the ALJ findings. Then the statute tells us to ignore them. So why do they have talismanic provenance when the commission disagrees with them, but would have no deference if the commission agrees?
Yeah, that's a fair question, because optically it would look like you were still deferring to the commission, but in fact you would be looking past the commission and deferring to the ALJ. Now, in the case of an honest commission that affirms the ALJ, it wouldn't have observational difference, but in the case of a commission that reverses, you can see what's going on, which is the court in that case where they agreed would look straight through the agency, defer to the ALJ, particularly on these credibility determinations. I mean, this isn't even a revolutionary concept. It goes back to Duncan versus Mack and many, cases that are 100 years old. And so that's like one of the big reasons to defer. And, because I only take the easy cases, that fully disposes of this one. If you just agree with me on one thing, which is we should defer to the ALJ who saw live testimony, either as a due process matter or a statutory construction matter, this case is done. Complete affirmance. But I assume the court took it to provide a little bit more guidance, and so there are other reasons to defer to the ALJ. The other one that I want to highlight is that the legislature is presumed to legislate against the background of existing precedent. And when the Court of Appeals decided Whitland, which under the old law, pre-amendment law, chose between the ALJ and the agency, the Whitland court struggled mightily with which to go with. And it pointed out that there are a minority of states that defer to the ALJ and not the agency. And while trying to preserve some deference for the ALJ that didn't exactly materialize over time, Whitland said Arizona is going to go with the majority rule. Against that backdrop, the legislature has taken away deference, but only for the agency, which is another part of the text that the other side consistently overlooks. They've subtracted deference for the agency, which leaves who? It leaves the ALJ. So if we take seriously the canon of construction that the legislature works against the background of the court's precedent, then if the choices were A or B, and the legislature says not B, A remains a candidate for deference on everything, not just the credibility determinations.
Well, moving to a different substantive question, I was asking your adversaries, what difference does the fourth sentence make after this statutory change? But I have to ask you, what's left of the second sentence? They are entirely correct that this section has been amended on multiple occasions and no change has been made to the substantial evidence rule. Where does that now fit in our equation, or was the legislature guilty of something we say that it can't do, which is to repeal by implication?
Certainly not. The other side, they have a number of ways that they try to come at this, but they all boil down to ignoring the fourth sentence in favor of the second. Here's an immediate
I got to accuse you of doing the exact same thing except in reverse.
Well, Justice, no, because the introductory clause of the fourth sentence has to mean something. In an action brought by or against a regulated party, you have a new rule taking away deference. You have what we all agree.
As to fact findings.
Sure, and the preceding sentence is the exact same thing, the exact same clause, by or against a regulated party on legal questions.
Right.
Now, in my mind, once the court is doing its own legal interpretation and its own fact finding, there's not a lot left to do. I mean, I don't know what else there is in the regulated party case. Now, in many, many other cases, including the ones that Mr. Torrey says were decided between the amendment and our case, like Shin or Red Mountain, that involve non-regulated parties, the Attorney General's brief, which is superb, if that's a brief in support of neither party, the court can go ahead and rule in favor of neither party. That is a great brief. And it explains that there are lots of cases, the Patagonia case, where you have non-regulated parties who sue over an agency action. That was the environmental case where, not the permittee, but an environmental group had sued ADEQ over the issuance of a permit. That would be a non-regulated party, as the Attorney General points out. Now, the other side says...
on that, though, it kind of made me wonder when I read that, wouldn't you have to bring in the permittee as a necessary party, and wouldn't then it be against the necessary party as well?
No, I'm not sure that's true at all. No, they probably would intervene to protect their interests and support the agency, but the agency could absolutely go it alone. And this gets to one of the points that, or take Shin, which Mr. Torrey cited. Shin is an employee case. Now he says, oh, don't worry, employees are regulated parties because they have to follow a handbook. Like there's an employee handbook at issue. No one thinks that that is a regulated party. And then later in their brief, it's page 8 of the Jerry's brief responding to the Attorney General, they talk about the how anyone under any reasonable construction of regulated party would know that an environmental group is a regulated party or something like that. So they appear to have some sort of working definition themselves. It's inconsequential that the statute doesn't define regulated party because, A, it's forfeit in this case, as the Court of Appeals noted. I believe it's paragraph 74. B, it's very clear that, 64, there's no question that a racetrack owner who needs a license in order to continue operating his racetrack is a regulated party. The court could feel free to offer a definition of regulated party, but this case doesn't really present it, and I think it would probably be dicta in future cases.
May I ask you, before you go too far down the line on regulated party, in answering Justice Bullock's question, I was surprised you didn't mention earlier you said this is a targeted statute, the targeted fact-finding, which at least I saw it a little bit differently. A trial de novo is a whole trial. It's a do-over under D, whereas at least A and F seem to be more particular questions of fact that are raised. So it's not the whole thing. So if that's so, why couldn't you have the superior court being not giving deference and making the fact-finding as to particular facts, yet then when you get to substantial evidence review, decide, yeah, even though I may have changed my mind or I have a different view of a particular fact, nevertheless, there's still substantial evidence that supports the agency's determination. So I guess I don't see how they are mutually exclusive concepts.
Okay.
Could you elaborate on that?
Yes. Well, I think the best way is to look back to the text, which says that the court shall decide all questions of fact. So there are no questions of fact on which the agency is making a decision. The agency fact findings are leveled in regulated party cases.
Well, why couldn't you say questions of fact? Questions to me means somebody's bringing up a question of fact. So why couldn't it be in this case, for example, your client coming forward to say, hey, there's this fact that was found by the commission, the ALJ, whomever, is completely wrong because here's other evidence.
Justice, I'm not sure that there's a structure by which you identify particular fact findings, although in this case we challenged the essential ones, and so it probably doesn't matter. But the way that I read this, and I think it's the best way to read it, is all questions of fact means all questions of fact. So any fact dispute in the case between the parties, the court shall decide that. Now, you have special circumstances in C and D for enumerated cases where there's a trial de novo, and in that case, clearly the court is going to make a whole new record, not even just reviewing the record, but making a whole new record. And in that circumstance, it doesn't make sense to talk about, it renders this superfluous. So the other side says the fourth sentence added in 2021 is just talking about D when you have a trial de novo. That way lies madness. If you have a trial de novo, you don't need to have authorization to make all fact findings without deferring to the agency. If you're having a trial de novo, you're not deferring to anybody. So that renders the fourth sentence superfluous. It can't be that. And so the same thing, I guess, would be true in A if you have a hearing to augment the record. But that goes to what is in the record. And paragraph E, echo, talks about what the record is comprised of. And the record includes basically the administrative record, including the ALJ decision, plus anything that's done in Part A, or the record of a de novo trial. So the statute, I think we point this out in the supplemental brief, the statute distinguishes between these situations, the de novo trial on the one hand and a review of the record on the other. But the review of the record is done according to F. F begins by saying, and A, by saying you review the record and do the following. A couple of other sort of stray points from the presentation that you heard from the other side. They have this magic words theory that you have to say de novo in order to have a fresh review of a case. That's obviously not the case. There's no requirement that the legislature says de novo. We cite Black's Law Dictionary in the supplemental brief for the fact that deciding all questions of fact without reference is a de novo review. There are two de novos in legal vocabulary. There's trial de novo, and then there's also de novo review. Neither of these is alien, but there's no requirement that you say the magic words de novo instead of just explaining, as the legislature did. That's like saying you have to say 6, you can't say half a dozen. There's no requirement of that sort in the law as long as it's clear. Moreover, the third sentence says the court answers all questions of law without deference. It doesn't say de novo. So be careful not to latch on to this concept that there's a magic words requirement. The other thing that I want to point out is, and I'm circling back to two concepts, the ALJ deference, and then maybe in the case of a hearing under A, how would the appellate courts handle their relationship? Because the Attorney General's brief does a great job of explaining, based on M&M auto storage, which is a canonical case, that all of the courts have the same position vis-a-vis the agency. That would obviously not be the case if there had been a new trial in the Superior Court, in which case the courts should review that in the normal fashion. But just a couple of months ago, this court decided, I believe it was the day after Thanksgiving, the Alvarez-Soto case, in which it explained that the fact finder who sees live testimony is able to view other testimony in the context of its credibility determinations. In this case, the only decision maker who ever saw live testimony was the ALJ. And so even the document review, when you have, like the contract, for example, is in the record that explains that the Bruin Corp is a landlord. And I know the court didn't grant review on the fact questions, thank you, in this very, very long saga. But all of those things are viewed through the context of the credibility determinations. I think Alvarez-Soto, it's paragraph 32, is very, very helpful in that respect. Finally, I think that we need to reject the concept that the regulated party means anybody who's affected. If that were the case, it would read the meaning right out of that clause. The one thing we know for sure is that clause has to have some meaning. It has to be doing some work. And it may be the case that the majority of cases brought against agencies in these cases are by and against regulated parties. But that doesn't mean that we should remove that, and wash out the distinction between the second and the fourth sentence. But the one thing that's absolutely certain, as I wind down in the last minute here, the one thing that's absolutely certain is that substantial evidence is no longer an option for reviewing agency fact determinations. Neither can there be deference on questions of law, of course, but this court has made clear that the statute has to have meaning, and it has confirmed in Horn versus Polk that this is a deferential standard. Just the next paragraph in Horn versus Polk, it's paragraph 14, the court notes that due process violations are magnified, the court's word, where you have a deferential standard of review. And to ascend the soapbox for just a moment, this case is one that I find myself more viscerally engaged in than almost any case I've been here on, because our state should be embarrassed of what happened to Ron Sims in this case and the way that he was railroaded by this commission. Consistent with that, please make clear in your mandate that they should grant the 2013 license application that has long been litigated, because if they have any wiggle room, I don't think they'll do right by my client. And he has since applied to renew, and all those renewals have been held in abeyance. So we need the 2013, which is the subject of the litigation. I'm not pulling a fast one. We need that to be issued. Thank you.
Thank you, Mr. Dre. Okay. Going to be Mr. Torrey.
I'm going to talk really quick because I know Chris wants to talk. I'm not sure why we're even talking about deference to the ALJ. Ritland tells us that because the statutes let the agency make the final decision and the statutes let the agency change any decision of an ALJ, then there is no deference to the ALJ, and nothing in the amended statute changes that. I'll also point out that the language about the regulated party has existed since 2018 relating to Chevron deference, and nobody ever thought that that limited the elimination of Chevron deference. Finally, responding to Mr. Dre, his magic words, he's obviously not a textualist, but when the legislature uses a word like de novo in one part of a statute and leaves it out of the other part of the statute, the law is plain that they did not intend to include it. So by including it in D and not including it in F, they clearly did not intend to include it in F. Thank you.
Apologize for all the shuffling between us here. All right. With a minute 30, I'm going to hit these points rapid fire. So Mr. Dre just told you that substantial evidence is no longer an option, yet he never explains how that's the case and why the legislature left it in the statute. That you cannot conclude substantial evidence is no longer an option when it is still in the statute. And as for the statements in Hornby Polk and other cases that substantial evidence is, quote, deferential, the legislature knew of the statements in cases like that when it drafted the 2021 amendment. Had the legislature wanted to eliminate substantial evidence because it believed it was an overly deferential standard, it could have and should have done so. It left the standard intact. So no deference in the fourth sentence cannot mean no substantial evidence in light of that. There's a lot of discussion about ALJ findings. There's nothing at all about that in SB 1063. Nothing at all. You can't ever look past the agency, as Mr. Gray suggests, because Title 41 prohibits that. The agency always makes the final decision. The ALJs are just recommendations. By statute, the ALJs have the power to render the final decision by modifying, reversing, or affirming, in the case of a hypothetical Justice Bollock asked, the initial ALJ decision. And then just two final cleanup points. First off, there's no due process issue before this court. The court did not grant review on that. And then finally, de novo and no deference aren't necessarily synonymous with each other, because the whole point of overturning Chevron in 2018 was that we reviewed legal issues de novo, but applied a deferential standard there. They're not necessarily synonymous. Thank you.
Thank you, Mr. Herring. I thank all counsel for the excellent oral argument today and the briefing on this matter. Before I adjourn, I neglected to do one thing in starting out, and that was to recognize that Justice Montgomery has recused himself in this matter. So we have Judge Michael Kelly, who kindly came up from Division II of the Court of Appeals to sit with us. So we thank you, Judge Kelly, for doing so. And now we stand adjourned for good.
Good to see you. Yeah. Good to see you.